So they decide to go for broke. They decide to go for broke and try and end segregation in public schools with a case from this little girl, Linda Brown. Linda Brown went to a one-room schoolhouse, and this was the white school back behind her. And this is what's going on. Again, you have the South is making progress. They're actually spending millions of dollars to try and bring up schools for African Americans in the South. The fear was if they failed, they might reaffirm Plessy, and then all these building programs for black schools in the South would end. That was a fear. But they decided to go for broke. And this is what happens. The Supreme Court rules in their favor and says segregated schools are unconstitutional. As well they should have. And they actually, and this is rare when they do this, they actually said we, meaning we the Supreme Court, were wrong when we decided Plessy versus Ferguson. Now the reality is the judges who served on the court in 1954 were not those who served in 1896. But when they say we were wrong, meaning we the court, but it's rare that the Supreme Court overturns a previous court case that they have decided by name, and they did in this instance. Usually what they do is they carve out an exception. They say, this is different from that case, and now this is the approach we're going to take. But they wanted to send a clear message that segregated schools were unconstitutional, and that's what they did. Now, the way they did it was they used a social science approach. There was a social science study that separation had a detrimental effect upon the colored child by generating a feeling of inferiority as to their status in the community that may affect their hearts and their minds in a way unlikely to ever be undone. Now, this is interesting. This is interesting as a statement of itself, but the reason it's so interesting in this case, and don't get me wrong, I believe the decision is correct, but here's the challenge. Why did the Supreme Court use a social science study to say that this is unconstitutional? Doesn't the Constitution mean what the Constitution means? So why did they use this approach? And does this mean any study can impact what the Constitution means? I thought the Constitution meant what the Constitution meant. Well, here's why they did it. When the 14th Amendment was proposed, debated, and adopted, Washington, D.C. had segregated schools. And at the committee hearings on the 14th Amendment, it was asked whether or not the 14th Amendment would ban segregation if passed during the debates in the committee hearings. And they said no, it would not. That the 14th Amendment did not, the intent of the 14th Amendment was not to end segregation in public schools. So then the reason the Supreme Court used a social science approach is because how do you say that the 14th Amendment now ends segregation in school when at the committee hearings they said it would not? So that's why they use this social studies approach. Was this a judicial activist decision? Yes. Was there any way around it? No. Other than saying that the committee members who had these debates were being disingenuous, and that presents a whole other set of problems. That they were saying one thing and meaning another. This is what happened. Should it have happened? Yes. And therein lies the rub. How do you say that judicial activism is okay in one sense and it's not okay in another case? But that's what happened. Now, moving on. Oh, in addition to that, after the 14th Amendment was passed, when Congress was debating a Civil Rights Act, it voted down a provision which would have ended segregation. Again, so I ask, how do you now say that it is unconstitutional? Again, that is why they use this social science approach. Now, so what the Supreme Court declared in Brown versus 1, and notice right here I put Brown 1, 1954. This is known as the decision, because next year in this court there's going to be a Brown 2, 1955, which is going to be known as the implementation decision. So in Brown 1, the decision, the court said, separate but equal has no place in public education. Such laws are inherently unequal. And then, as we said, they overturned Plessy by name. So the Supreme Court realized that when they were passing this, when they were ruling on this case, that they were changing the fabric of the South, the social fabric of the South. They realized they just couldn't say segregation is now unconstitutional, fix it. So what they asked the parties to do in this case, meaning the government, who was arguing in favor of segregated schools, and the NAACP, who was suing on behalf of little Miss Linda Brown, and all hail to Linda Brown for what she did, a brave little girl. They asked them to come back the next year and tell them, the court, how they should fix it. And so this becomes known as the implementation decision, how they're going to implement it. And so what they ultimately decided to do in this, the operative words in the court's decision in Brown 2 in 1955 was that states were to desegregate with all deliberate speed. All deliberate speed. What does that mean? It sounds like speed. Speed seems to have a connotation fast. Deliberate is thought out. It's careful. So if you really look at this phrase, all deliberate speed, the court wasn't saying just rip it up, tear it down, and get it done fast. They were saying be careful. Go to pace. Speed does not necessarily have to be fast. It's just a rate of progress. They're saying be careful. Be careful how you do it. In other words, they were saying go fast, slowly. That's the way one historian put it. Now, the sad thing for all this was all deliberate speed turned out to be at a snail's pace. Turned out to be at a snail's pace. And so finally, we'll get to the finally in a second. Let's back off on that for a second. So here is, so we got to go fast slowly. Now, there's a problem left by Brown 2, a number of problems left by Brown 2. So what did an unsegregated school look like? If segregation was unconstitutional, what does an unsegregated school look like? Were people just free to go to the schools of their choice? Were they free to go to neighborhood schools? After all, blacks seem to live in certain neighborhoods and whites seem to live in other neighborhoods. And so one of the things that the court's decision did make clear was de jure segregation, and that is segregation by law. This kind of law that says whites go to this school, blacks go to this school, that is clearly unconstitutional. But what about de facto segregation? De facto segregation is segregation in fact. It is shaped by economic realities, social forces, and preferred living patterns, things like that. Is that unconstitutional? In other words, were the states allowed to just let people go to the neighborhood schools, or did they have to actually integrate? And eventually the court ruled, and pretty quickly, that they needed to integrate. And so the court ordered, based on Brown 2, they ordered school busing to bus black children to white schools and white children to black schools, so you had this integration. This was real problematic for everybody. You had kids at the time who were on the bus to school an hour and a half both ways. They're in a commuting situation. They might as well be driving downtown to L.A. But the problem was you had blacks in the inner cities most often and whites in the suburbs, and so how else did you integrate them? And so that's why the court ordered busing. Now, this didn't just last for a little while. It wasn't until 1993 that the court finally, in a sense, gave up. And they said, okay, we've tutored you along for a while now. Now it's up to you. And so they removed themselves from the busing question. Since then, our patterns of living have changed. Yeah, there's still issues within inner cities, but you're always going to have those issues. It's not the kind of segregation that it looked like when the law was saying that no, blacks couldn't go here, only whites. This is a de facto. If there is segregation, it's because of these social living patterns. You have blacks in rich neighborhoods, particularly as African Americans have done better financially. and all that. You've seen social classes, not so much racial classes, develop in the United States, and that is itself a whole nother question. All right, so finally in 1993, the Supreme Court removes itself from the busing question, but you can see the progress here that the Black Civil Rights Movement made in the courts. And so now this was happening simultaneously, but then the campaign in Congress begins to heat up during this whole process as more and more rights are achieved. So we'll pick up there in the next video.